Bila shaka nataka tuelekee katika jumba la Seneti ambalo linaongozwa na Amason Jeffa Kingi, spika wa bunge hilo, tayari akiendeleza mjadala kuhusiana na kumanduliwa kwake gavana wa Isiolo Abdi Guyo, ambaye leo hii, kesho na kesho kutwa atakuwa na wakati wa kusikiliza mashtaka yaliyowasilishwa dhidi yake. Jumatano atakuwa anajitetea. Alhamisi itakuwa ni siku ya maseneta kuweza kujadili yote na kutoa uamuzi wao kuhusiana na kile ambacho kitakuwa kimejadiliwa kuhusiana na hoja hiyo ya kumbandua mamlakani. Ufahamu kwamba wawakilishi wadi 16 waliidhinisha hoja ya kumbandua mamlakani Abdi Guyo, na kati ya wale 18 huku wawili wakikosa kupiga kura ya mjadala huo. Hebu tusikilize kinachoendelea katika bunge la Seneti, takujuza mengineo baadaye.
Senators, it is therefore not in any doubt that the Assembly set the hearing of the motion at 9 a.m. 26th of June. I now refer the Honorable Senate to the Isiolo standing orders. Standing order, specifically standing order number 1. It is found at volume 3, pages 85 and 86, on the times set for the sitting of the Assembly, and that is 9 a.m. for Wednesdays and 2:30 for Tuesdays, Wednesdays, and Thursdays. I do not need to say this because you're familiar with these times. It therefore follows that if the Assembly is to meet at any other time other than as set out in the standing orders, there must be a resolution to that effect. And so, therefore, the logical question that we are asking the Senate is this: is the Hansard genuine? Because the Hansard talks about a sitting conducted at 2:30 p.m. That is in line with the standing orders. But the notices, the invitation, and the special sitting issued by the Speaker talk about a sitting to be conducted at 9 a.m. So therefore, Honorable Speaker and Honorable Senators, we invite you, the Senate, to take note of the above, and then allow us to also review the Hansard that is provided. You probably understand the Hansard much better than we do, and I refer you to the Hansard for the 18th of June 2025, which clearly shows that the Assembly was adjourned to 26th of June at 2:30 p.m., and I refer you to volume 3 still of the Assembly's documentation. The issues that you will note when you review the answer is that, first of all, it is not certified by the clerk as is required. It just bears a stamp. It is therefore our submission that these latent, open, obvious, and blatant contradictions and anomalies between the Hansard and other records provided by the Assembly are major indicators not only of misrepresentation, but that the documents presented by the Assembly have been cooked and generated outside of the Assembly. This is further supported by the testimonies of the witnesses, which will be found at volume 2 of the Governor's response at page 14, where we have the affidavit of Salad Boru Gurasha, who was the clerk of the Assembly, who confirms that there was no sitting of the Assembly on either date. There is an affidavit by the Leader of Majority, Diba Ali, at pages 41 to pages 45, who confirms there was no sitting of the House Business Committee to deliberate and set out the order papers. Further, We have the affidavit of Shaban Mzungu, who was in charge of security at the assembly on that particular day, and he confirms that there was no sitting of the assembly. Honorable speakers and honorable senators, we expect that the assembly will try to persuade you that the issues we raise are not preliminary and they require a full evidential hearing. But allow me, honorable speaker and honorable members of the Senate, to refer you to the assembly's submissions on the preliminary objection, because they have filed submissions on the preliminary objection and they have quoted a decision. And the jurisprudence from the courts is that a preliminary question is determined on the presumption that the facts pleaded are true. The facts that we are raising are the facts that have been pleaded by the assembly. And that preliminary issue, when determined, may as well as dispose of the suit, and it is for that reason that we raise it as a preliminary issue, because if this Honorable House was to find that there was no sitting of the assembly, then we cannot proceed with the hearing of the impeachment motion. And so we submit that these questions that we have raised satisfy this threshold, and we invite the Senate to look at the facts that have been pleaded by the assembly and the documents that have been provided, and agree with us that this is a case of a phantom impeachment. Finally, as I, with one eye on the clock, we submit that this process is a hallowed process. It is not just about whether the grounds set out in Article 181 of the Constitution have been met. If the Senate is to examine whether there was a valid resolution and agree with us that the documents that have been presented are forged and cooked, then this impeachment, this phantom impeachment, amounts to an affront on the Constitution, and it sets a very dangerous precedent, because what it means is that it is possible for the Speaker and a few members of a rogue assembly to, in a way, attempt a coup, sit somewhere, cook documents, and present it to the Senate, and the Senate will then hear that matter. That in itself will be a violation of the Constitution, because this Senate has a mandate to protect devolution and to protect the counties. And that is the danger that we face in these phantom impeachment proceedings. Honorable Senators, the impeachment proceedings not only put the governor on trial, it does the same for the Constitution. It does the same for the Senate, for the members of the county assembly, for the witnesses, for the lawyers on either side, and ultimately the Kenyan people. It is our humble submission that the Kenyan people vested the power of impeachment in the Senate because they expected that the senators had special qualities, numbers, and temperament to rise to the occasion, and we urge this House to rise to that occasion. Finally, before I cede ground to my fellow counsel, allow me, Honorable Speaker and Honorable Senators, to just remind you of the words of Alexander Hamilton, one of the founders of the American Constitution, on the power and the question of impeachment. Hamilton explained that the senators were seen as the ideal arbiters in an impeachment process because the Senate would be a tribunal sufficiently dignified, and sufficiently independent of the factual interest aligned in the subject of an impeachment. We urge this House to rise to this occasion, and we respectfully urge the Senate to review the material that we have provided and to find that there was no sitting of the Assembly that gave rise to the resolution that is before you for consideration. And Honorable Speaker and the Honorable Senators, I thank you for the opportunity you have accorded us to address you on this issue, and I invite my senior Elisha Ngoya to take us on the second limb of our preliminary issue.
Thank you so much, Mr. Speaker, and thank you, distinguished senators. As indicated, my name is Elisha Ngoya, lead counsel for the Governor. Before I address you on another substantive preliminary question on an existing court order touching on these matters, allow me to invite my learned colleague, Mr. Elias Mutuma, to wind up on that issue of the proceedings before the Assembly by drawing your attention to certain salient material aspects of the purported Hansards that have been presented before you, so that you have all that in consideration. Then I'll move to the next subject. Thank you so much, Mr. Speaker.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity. The council representing the County Assembly will be here shortly to try and convince you that what we have raised is not a preliminary objection, but requires an interrogation by way of listening to witnesses and making a determination based on what they will say. But our submission is simple, honorable senators, that what we have raised is a pure PO that can be addressed and determined based on what has been presented by the County Assembly of Isiolo. Honorable senators, my understanding of Hansard's records is that they are a verbatim record of what transpires in a House proceedings. Therefore, they are able to tell us exactly what happened on the day that that motion is said to have been passed. We have raised an issue with proceedings that are said to have taken place on the 18th of June 2025 and proceedings that are said to have taken place on 26th of June 2025. Honorable senators, with your kind permission, kindly hold your volume 3 of the County Assembly's documents. I will take a very short time to take you through the Hansards, and this being a house that is also a house that is very much familiar with proceedings in the House, you'll be able to tell me whether there is anything that took place there. At page 7 of that bundle, we have been presented with what is said to be the proceedings of 18th of June 2025. Page 7 of 7 of volume 3 of the documents. Page 7. We see the House purportedly sitting for the first time. There is no communication from the chair. There is no calling of orders by the clerk. Straight away, the mover of the motion proceeds to execute the business of the day. Look at it. It is straight away withdrawal of the motion on the impeachment of Isiolo County Government dated 10th June 2025. What does it begin with? Honorable Abubakar Godana. Honorable senators, who presided over this session? There is no invitation from the Speaker for the mover of the motion to proceed and execute the business of the day. Let's proceed. Honorable Abubakar Godana proceeds and proposes a motion to withdraw the previous motion and invites two members of the County Assembly, Honorable Nicholas Lorot and David Nyoro to second the motion. Without again the intervention of the Speaker, these two members rise and they proceed to second the motion. So who invites them to the floor? Who is presiding over this House? Let's go on. The two members support the withdrawal of the motion, and the Speaker now is seen for the very first time. There is no question put to the members. There is no vote that has taken place, but the Speaker proceeds to say, the members, the notice of the special motion or the removal from office by impeachment, the Governor of Isiolo County issued on Tuesday, 10th June 2025, has been officially removed as requested by the mover, Honorable Bakar, member for Sericho Ward. We now proceed to the next business. So who approved this withdrawal? Who approved this withdrawal? Where is the vote? Let's proceed. Honorable Senators, we proceed to the Hansards now of 26 when the Governor is being purportedly impeached. That's at page 23 of the same document. There is a communication from the chair. The first order of business, you will come across the order paper at page 17, where we have a total of 8 orders of the day. 8. But when you go to page 23, we do not see the clerk calling out the orders. Just look at it. It is the Speaker directly proceeding to make a communication. Is that an anomaly, Honorable Senators? We are all familiar with the business of the day. But what intrigues me more, Honorable Senators, the first order of the day here is to lay on the table the purported public participation report, which is done by Honorable David Lemantile, allegedly. He prosecutes his motion and argues on the public participation. Let's go to the end at page 31. But before that one, let's go slightly at page 30, where he completes his submissions. After laying the paper, public participation, we now see Honorable Peter Losu standing up to second this motion. Who has invited him to second this motion? Out of nowhere, he's not invited by anyone, but Hansards show that he rose to second this motion. And then the Speaker proposes the question and opens the floor to the members of the House. At page 31, the last member seen to be speaking is Honorable Francis Letimalo. The Speaker now puts the question. So what happens after the question was put, Honorable Senators? There is no record whatsoever of what transpired. Nothing. A question is put, there is no indication that the House actually endorsed the public participation report. That Hansard is left hanging. Honorable Senators, after that paper is laid, the Speaker does not even call for the next order. The clerk is not seen anywhere calling for the next order. Instead, what do we see? Honorable Abubakar Godana is seen now on the floor, Hansard are supposed to be capturing verbatim what transpires. So who was in charge of this house? Where is the speaker's recording inviting the mover of the motion to move the motion? Where is the recording of the clerk inviting, or rather calling for the order, for the next order? There is nothing. Instead, we just see someone on the floor prosecuting the motion. And he proceeds and proceeds. At page 35, he's done. Strangely, the first paragraph at the top of page 35, when he completes to execute his motion, he does not invite anyone to even second. Records are there. But we see one Honorable Major Golicha now standing up to second the impeachment motion. Who has invited him? There's no one. And other members, strangely now, so the House is suddenly in an autopilot. So from Honorable Major, then we see the Speaker opening the floor. You have Honorable Peter Losu. He continues. Without the intervention of the Speaker, there is another member, Honorable Salesio Kiambi, who proceeds as if the Speaker is not in this House, as if the clerk is not in this House, and proceeds. Another member just rises up from nowhere. There is no recording of the Speaker inviting any member to make a contribution to this motion. Apart from, of course, page 39, when suddenly the person cooking this answer realizes the Speaker has not been captured in this, and now we see the Speaker for the first time. In conclusion, because I do not want to take time that my senior is going to take to address you on the other issue, look at page 41. After the members purportedly complete to make their submissions, the Speaker makes very strange remarks, and I quote at page 41. Clerk, is the Governor or his legal representative available? Sergeant at Arm, can you check around if the Governor or his legal representative are present? The Speaker does not even take time to communicate to the House whether the Governor had been invited. He does not even read that invitation notice as required. So why is he calling for the Governor, whom Learned Counsel had told you was invited to appear at 9 and we at 2 o'clock? The Speaker is not seen anywhere saying that we invited the Governor by this letter and he has not come, but instead asked the clerk to check whether the Governor is available anywhere. Let's proceed. I'm completing, Honorable Senators, and this is going to shock you. So, when the Governor was confirmed was not in the House, the Speaker proceeds to guide the House on the next move. At the end of that page, 41, I read what the Speaker says. When the doors, I'm reading the last part, when the doors have been locked and the bar drawn and the names of the tellers have been announced, the Speaker shall, this is the Speaker telling them, the Speaker shall put the question again in the presence of the tellers. When called out, each member shall thereupon rise in his or her place and declare assent or dissent to the question in the following manner. I vote yes or I vote nay. Proceeds. Honorable Senators, page 42. Where does the Speaker put that question to the members of the House present? There is no question put whatsoever. She has just told them that he needs to put that question again. There is no question put. So what were these members voting for or against? There is no question put. Honorable Senators, we then need to sit here and invite witnesses on the stand to demonstrate that there was no proceedings that took place on 26th and 18th. I rest my case.
Thank you, Mr. Speaker, and thank you, distinguished senators. I'll proceed to argue the final limb of the objection, but just to cap up what my learned colleagues have told you, that if before you is a purported Hansard in the form and content that you have been taken through, if before you is a purported Hansard that no one has taken the courage of his or her conviction to certify, if somebody brought before this House a Hansard that is not certified, because certification is done by a particular officer whose signature we can tell, is what is before you a Hansard of the County Assembly of Isiolo or a mere piece of paper? And if we conclude, as I invite you to, that what is before you is a mere piece of paper, to the extent that it is not certified, can we take any other proceedings on the strength of that mere piece of paper? That is what makes this issue a proper preliminary objection for resolution, one way or the other, before we can go into the trial. Secondly, is the issue of the order of court. And I want to address this issue as follows. We are guided by the Constitution and other laws and the standing orders, and to an extent, the manuals that this House publishes from time to time to inform both these members and the members of the public who interact with this House. My research has revealed that the latest manual issued by this House is a manual entitled Removal from Office of County Governors and Deputy County Governors through Impeachment, an easy-to-use manual on the procedures and rules. That manual, on the face of it, was published by the Directorate of Legal Services and the Senate Liaison Office in the year 2025, which is this year. Part 3 of that manual is entitled Judicial Proceedings Against Impeachment. And this is the position this House has communicated in that manual at page 60, which is the very last page of that manual. There are 2 subtitles at page 60 of that manual, which is subtitle 1, Comply with Court Orders. And it says, parliamentary privilege and immunity and the principle of separation of powers do not shield the county assemblies and the Senate from court orders. When court orders are issued, they are binding on the county assembly and the Senate and must be complied with. Failure to comply with court orders may result in the invalidation of the entire process of impeachment by the courts. Then the second subtitle is participate actively in court proceedings. And this Senate has communicated to us through this manual that ignoring court orders against the county assembly or the Senate is not the solution. If court orders are issued against a county assembly or Senate, the most preferable option is to participate actively in the court proceedings. The county assembly or Senate may apply for review of the court orders or appeal to the next court for variation or the setting aside of the court orders. That is the manual that this House has published as late as this year. Allow me to make the following submissions then. The existence of the orders of court I am going to refer to is not a disputed fact. It is a fact admitted by the county assembly in their written submissions. So the existence of these orders is not a contested issue. And it not being a contested issue, it follows therefore that this Senate can proceed right away to resolve the question of the impact of those orders without investigating whether they exist or they don't exist, because between the parties, it is an admitted fact. Allow me to begin by referring this order, this Senate, my apologies, to an earlier ruling of the Speaker of the then only House of Parliament, which was the National Assembly before the new constitution. This was the ruling by Speaker Kenneth Otiato Marende on the question of nominations of Chief Justice, Attorney General, Director of Public Prosecutions, and Controller of Budget, and that ruling was made on the 17th of February 2011. It is found in volume number 4 of the Governor's documents. It is found in volume number 4 of the Governor's documents, and you'll find that ruling starting at page 165 of volume number 4 of the Governor's documents. But the relevant part I will refer to in the interest of time is at page 168 of that volume, volume number 4 of the Governor's response. At page 168 is a continuation of that ruling of the then Speaker of the National Assembly, Honorable Kenneth Otiato Marende. He says, and I quote, "Honorable members, between the time when Mr. Imanyara first raised the matter and now, I have had the benefit of considering a range of material addressing the various aspects of the matter. Specifically, I have benefited from, among others, the position taken by the Judicial Service Commission, the Commission on Implementation of the Constitution, and the Law Society of Kenya. I have also carefully read and considered the ruling of the High Court relating to the matter of nominations, which was delivered on 3rd February 2011. Mr. Speaker, distinguished senators, I had the rare privilege of participating in that court proceeding. The first three of these bodies are constitutional or statutory, and their views on matters of law, though not binding to this House, are of significant persuasive value. Honorable members, as for the ruling of the High Court, despite my restatement of the constitutional relationship between the legislature and the judiciary, I have repeatedly emphasized that subsisting judicial decisions, while they cannot restrain the legislature, and that's important to us because I'm addressing this issue, while they cannot restrain the legislature from the discharge of its functions, are of binding effect and may have a bearing on the products emanating from this House. The learned Honorable Justice Musinga, in his ruling in the above case, found that the nomination of the Chief Justice was unconstitutional, for it was not in accordance with Article 166 of the Constitution. I will then proceed to page 169 of that volume in the interest of time. The paragraph starting with honorable members, that will be the third paragraph. Although I have read that this court decision does not stop the National Assembly from proceeding with its work and cannot determine for the House how to proceed, it must be noted, as matters currently stand, any decision made by this House on the nomination, though perfectly procedural from the point of view of the legislature, outside the legislature, it is, to the extent that it does not accord with the ruling of the court, null and void for all purposes. So that is the guidance that Honorable Marende makes. Allow me to then come to the specific ruling that we wish to draw this Senate's attention to, and that I will refer you to volume number 4 still. Thank you so much, Mr. Speaker. And as somebody who has been here multiple times, I am always impressed by the support we get from the administrative teams in this Senate. That may have to go on record in the interest of posterity. At page 13 of volume number 4 is a decision of the court in Isiolo High Court Constitutional Petition number A004 of Abdi Ibrahim Hassan, the governor now before you, as petitioner, and the County Assembly of Isiolo, now before you, as the first respondent. There are two other parties in that matter, but safe to highlight that the parties before you are parties in that suit. They are therefore bound by the decision of that court. At page number 25, allow me to just go straight, Mr. Speaker, to page number 27. You'll find a paragraph 28 of that ruling. And the judge observes as follows: it is important to note that there was no complaint raised when the first orders were issued by the court in respect of the motion dated 10th June 2025 that was to be debated on 17th June 2025. In fact, the sentiments by the mover of that motion, the contemnor, actually vindicates the court, as he has in his affidavit conceded that the motion was defective in substance and marred with procedural irregularities, the very grounds that the petitioner has sought to rely on. The mover of this motion went to court and told the court, it is true that the orders you gave first were right, because the motion I had tabled was marred. It was defective in substance and marred with procedural irregularities. The move of the motion. Allow me to then take you to paragraphs 45, 46, and 47 of that ruling at page number 35 of volume number 4. Paragraph 45, the judge says, therefore, it is the finding of this court that the motion dated 18th June 2025 and debated by the first respondent on 26th June 2025 was in contravention of the conservatory orders of this court issued on 25th June 2025. Hence, the resolution arising therefrom is null and void. Once an act is declared null and void, it is of no legal consequence. A court of law has found that this motion, which has now been brought here before you, senators, is null and void. It is of no legal consequence. Paragraph 46. As stated, the resolution has evidently been submitted to the Speaker of the Senate. It is thus upon the Senate, once informed of the orders herein, which I'm now doing, Mr. Speaker, distinguished senators, to determine if it will proceed to handle the said resolution, thus abating a blatant disregard of the rule of law or the respect of orders. The matter at hand calls for a stand to be taken by the constitutional organs involved. What they choose to do will have set a precedent on the necessity for compliance with court orders. It is a choice between anarchy and constitutionalism. Distinguished senators, the judge is saying this. The judge is saying, I am aware. I cannot stop you from doing your work. So he's saying, proceed and go to Senate. And that, to my mind, was an extremely wise move by the judge, considering historical pleas for there to be institutional committee between institutions and to respect the powers of each organ. But the judge is saying, so you decide for yourselves how you will proceed. I have made a finding that that motion is null and void and of no effect. I want to contradistinguish this with other scenarios that the other side will draw your attention to shortly. The judge has not issued a conservatory order against the Senate. The judge has made a determination on the validity of the motion purportedly debated and purportedly approved by the County Assembly of Isiolo. The judge has made a determination. It is null and void and of no legal consequence. You are being invited to engage with this motion on that strength of fact on the strength of the finding by the judge that the motion as approved, as brought before you, is null and void and of no legal effect. We therefore invite you to introspect and make this determination. When the impeachment law calls upon you to determine a motion that has been approved by the county assembly, is it just any motion or a valid motion? If there is information before you that the motion is invalid for any reason, what is the precedent that has been set by this Senate? It is against that background that I wish to draw this Senate's attention to its resolution that is found from pages 136 of volume 4 of the governor's documents. And this was the determination of the proposed removal from office by impeachment of the governor of Kericho County, Honorable Dr. Eric Kipkoech Mutai. On that occasion, the validity of the resolution was questioned on the ground that the motion had not met the threshold. And rightly, this House found that it could not move a step further because validity of the motion is an important precondition to the carrying out of the trial process on the motion. Similarly, by parity of reasoning, today, validity of another motion has been impugned on two grounds. One, there was no sitting known to law of the County Assembly of Isiolo to approve the motion. And number two, in any event, a court of competent jurisdiction has made a finding that whatever came from the County Assembly of Isiolo is null and void and of no legal consequences. Will you, in the face of the precedents you have set by previous speakers' rulings and by resolution in the case of Kericho County Governor's case, proceed to trial on that understanding? We beseech you with humility to find that there is no motion known to law before you and thereby to down your tools. I humbly submit and respect and rest the governor's submissions on that question of the preliminary objections. I reserve our 10 minutes, Mr. Speaker, for a rebuttal from this side once the County Assembly has finished their response. Thank you so much, Mr. Speaker. Thank you, Senators.
Counsel for the County Assembly.
Mr. Speaker, I will respond to the arguments that have been made by my learned colleagues for the governor, and I am the only member of the team for the Assembly that will respond to those preliminary issues. Mr. Speaker, I am grateful for the opportunity to respond to those preliminary issues. I shall constrain myself to the time that Mr. Speaker has gladly extended our way. Mr. Speaker, I wish to start my response to those preliminary issues by stating that a preliminary issue, by definition, must be an issue that goes to the ability of this House to entertain the motion before it. It cannot be an issue that is merely important to the governor. It cannot be an issue that is merely important to the governor. Sorry, I cannot see my time. Thank you very much. It cannot be an issue that is merely important to the governor, and the governor then chooses to bring it forward and deal with it as a preliminary issue, and it does not go to the ability of this House to hear the motion before it. And, Mr. Speaker, it is settled that a preliminary issue assumes that the facts are settled. Mr. Speaker, the consideration of what the Governor's Council purports to be a preliminary issue involves the detailed consideration of evidence. I was constrained to stand up on my feet and object whilst my learned colleagues were on their feet, because it was apparent that what my learned colleagues were doing for the governor was leading evidence. They were testifying. They were referring to contested statements in the bundles of both documents, and there are responses from the county assembly in respect of those statements. And those statements must be tested by way of cross-examination. And only once the evidence is laid before this House and it is tested, like the assembly is entitled to do, then can this House make up their minds as to whether or not those issues hold any water. I am not saying that this House should not consider those issues, but what I am saying emphatically is that this House should not consider those issues as issues that are preliminary to the determination of the motion. There are issues in the motion, and I will demonstrate in a moment how those issues are indeed issues in the motion. I will choose, or I have chosen to respond to the issues that were argued by my learned colleagues for the governor, using a slightly different framework from what they did. We distilled 3 or 4 issues from the notice of preliminary objection that was served on the assembly, and I wish to crystallize the first issue I wish to respond to as follows, Mr. Speaker. That the governor challenges the validity of the impeachment motion in light of the declaration by the High Court of Kenya sitting in Meru that the impeachment proceedings are a nullity. It is correct, as was submitted by Mr. Ongoya, that it is not contested that indeed there are orders that were issued by the High Court of Kenya sitting in Meru in respect of these proceedings. But what is contested, and I doubt we will agree on this, is the effect of those orders on these proceedings. Mr. Ongoya and his colleagues say that the effect of those orders on these proceedings is to invalidate them, and this Senate should therefore down its tools. We disagree. I submit, and I wish to submit, Mr. Speaker, and emphasize that elections to offices, such as those occupied by the members of this House, are conducted by the people of Kenya in furtherance of primordial sovereignty. Mr. Speaker, the exercise of removal of an elected official, such as the removal of a governor, is therefore, in my submission, the flip side of that exercise of primordial sovereignty. And as authority to my submission, I wish to refer, Mr. Speaker and members of this House, to the provisions of Article 1 of the Constitution. Mr. Speaker, Article 1 of the Constitution provides as follows at Article 1.1. It states that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. That is an affirmation of sovereignty by the people of Kenya, and it is clear where the sovereignty lies. Article 1.2 then goes on to say that the people may exercise the sovereign power either directly or through their democratically elected representatives. The important provision of Article 1, which I wish to emphasize, is the next provision. Mr. Speaker, sovereign power under this Constitution is delegated to the following state organs, which shall perform their functions in accordance with this Constitution: Parliament and the legislative assemblies Parliament and the legislative assemblies in county governments, the national executive and the executive structures in county governments, the judiciary and independent tribunals. Mr. Speaker, the function of the removal of the governor is delegated to the Senate of the Republic of Kenya by virtue of Article 1.3. The election of the members of Parliament, members of the National Assembly, members of the National Assembly, members of this Senate, and any elected office is done directly by the people of Kenya. Mr. Speaker, As I have said, impeachment is the flip side of election, and it is done again here by the people's representatives. And here I wish to emphasize this point. Mr. Speaker gave a correct and appropriate direction at the beginning of these proceedings, that voting on this motion is by delegation. Voting on this motion is not by all members of the Senate, but it is by delegation. And I submit that that is in recognition of the special role, the special function that this House is being called upon to perform when you sit to consider the motion for impeachment. It is not legislative, but it is delegated, and the House has correctly interpreted that role as being exercisable only by delegations and not by all members. Mr. Speaker, it is my submission that a correct interpretation of the doctrine of separation of powers is as follows. Mr. Speaker, and it has been held not just by this House and not just by the High Court, the Court of Appeal, and the Supreme Court, that the role of the judiciary in examining impeachment proceedings arises or kicks in once the impeachment proceeding is complete. Yes, the judiciary has a role, but the judiciary then, as has been correctly held, does not have the ability to intervene at every stage. In our written submissions, Mr. Speaker, we have referred you to the relevant decisions of the Court of Appeal. We have referred you to the decision of the Court of Appeal in Kawira Mwangaza and the decision of the Supreme Court rendered earlier in the matter of Martin Nyaga Wambora. And I wish to suggest a reasoning, perhaps, why the law is as it is. Impeachment proceedings and many proceedings under our Constitution are time-bound. And if judicial intervention is allowed in some of these time-bound proceedings as they proceed, it is not clear whether the judiciary has the ability to suspend constitutional time so as to allow the judicial proceedings to proceed, or whether it is better off to allow the impeachment proceeding to proceed and be completed. And then what is taken is a process review of a completed proceeding to court. What am I saying? The correct interpretation of the doctrine of separation of powers, and it has been held repeatedly by this court, by this Senate, and by the courts, is that even where an impeaching assembly is making a mistake, allow it to complete the mistake. And what is then justiciable is the completed mistake. Don't interfere in between because of timelines, and that, I submit, is a modern interpretation of the view of the doctrine of separation of powers as to how it applies to the power of legislative assemblies, county assemblies, and this House to carry out their function of impeachment. Mr. Speaker, there was reference to a decision that was made by Kenneth Marende when he was Speaker. And it was a decision in respect to the appointment of the Honorable the Chief Justice of this Republic. And I wish to distinguish that decision from the matter that is before you for this important reason. Mr. Speaker, I have stated, and I will take your permission to emphasize, that impeachment are time-bound proceedings. The appointment of the Honorable the Chief Justice, yes, was a constitutional process, but it had no time limit. And the process of that appointment had the luxury of time. It could take as long as it needed to take, and it then made room in it for judicial interventions during the process of the appointment of the Honorable the Chief Justice. I have stated, and I will emphasize, that impeachment proceedings are time-bound proceedings. And if they are not concluded in time, we would then be faced with the ridiculous situation where somebody runs to court and say that Assembly X or the Senate of the Republic of Kenya did not complete their mandate in time. And I believe I was seated here a few months ago when the impeachment proceedings of the Deputy President of the Republic of Kenya were being conducted. And that was an important consideration, the strict timeline that guided many of the directions that, Mr. Speaker, you made during those proceedings. I urge you to call on that wisdom and to find, if you are persuaded to consider this as a preliminary issue, that because of the strict nature of the timelines, then the room for court or the role for court is ex post facto considerations of completed processes of impeachment. Mr. Speaker, there is a decision that has been referred to, and it is a decision that we advocates all know, and I'm glad, Mr. Speaker, you are an advocate, and I'm sure you are familiar with this decision. It is a decision that is referred to in the submissions by the Governor, and that is the decision of Lord Denning in the famous case of McFoy versus United Africa Company, where they seek to persuade, and in citing that decision, Counsel for the Governor seek to persuade you that because the proceedings are a nullity, then you should not proceed any further with these impeachment proceedings. I wish to rely on that decision, Mr. Speaker, and I wish to rely on that decision in an attempt to persuade you that it is indeed the proceedings before the High Court of Kenya in Meru that were a nullity. Coming as they did, contrary to the established law and contrary to the established interpretation of the modern doctrine of separation of powers, prior to the completion of the impeachment proceedings, those or that decision or references to that decision are a nullity, and you should disregard that decision and proceed. Mr. Speaker, I had a few passages from the decision, and Learned Counsel for the Governor seemed to be suggesting that the judge of the High Court in some way may have been directing this House as to what to do with its orders. I submit that this House is completely independent under the Constitution of the Republic of Kenya, and you should be guided properly as you then consider this preliminary issue. But in conclusion, I wish to state that this preliminary issue is not a preliminary issue. It is based on contested issues of fact, which we should then get the opportunity to look into. The second issue that I wish to respond to is an issue that when I first encountered it, I was a little concerned. And that is the submission that has been made by my learned colleagues for the Governor, and they have taken some time on it, that there were no sittings of the County Assembly of Isiolo on the 18th and the 26th of June 2025. They have used that submission in support of several grounds of their PO, and I wish to respond to that ground, and I wish to ask the House to apply it to all instances where they have made reference to the fact that indeed there were no sittings on the 18th and the 26th of June 2025. I wish to submit that that argument, with tremendous respect to the Governor and his team, is self-defeating. And it is a self-defeating argument if you look at it from this perspective. Mr. Speaker, it is the proceedings of the County Assembly of Isiolo of the 18th and the 26th of June 2025 that the Governor has taken to the High Court in Meru, and it has resulted in the decision of Mr. Justice Nyaga sitting in the High Court in Meru, which is set out, the order arising from Mr. Justice's decision is on, Mr. Justice Nyaga's decision, is on page 6 and 7 of volume 3 of the Governor's document. And the ruling itself is to be found between pages 13 and pages 37 of volume 4. And having based substantive legal proceedings on the proceedings of the County Assembly of the 18th and the 26th of June 2025, it then cannot fall from the Governor's mouth to come here before you this morning and assert that there were no proceedings. They have based substantive legal proceedings on the fact that there were proceedings. They have gotten certain orders from the High Court in Meru, which orders they seek to bring before you and urge you to declare the proceedings a nullity. I submit that they cannot. And for the completeness of the record,
Na bila shaka huyo ni Nyamodi, wakili huyo ambaye anasimamia upande wa bunge la Seneti ya Isiolo, ambaye amekuwa akipeana hoja zake kujibu zile ambazo zimewasilishwa na mawakili wake Gavana Abdi Guyo, wakilalamikia kwamba hata ile historia ambayo imekuwa ikiandikishwa katika bunge, basi nyaraka zake pia hazikuwa zinaendana na kisheria. Wamekuwa wakitoa malalamishi mbalimbali katika bunge hilo la Seneti, majibu ambayo yanajibiwa sasa hivi na wakili Nyamodi ambaye anawakilisha bunge la kaunti ya Isiolo.